As a court, please, my lord, at this stage, the state seeks permission to hand up certain exhibits in terms of section 212, subsection 4 of the Criminal Procedure Act. This is already on record, my lord. These are the affidavits of Captain Ntini and Captain Chrobla. I think her maiden surname is Felyun.
You intend calling Chrobla and Ntini?
We don't intend calling them, my lord.
Those affidavits, what are they for?
Yes, these affidavits merely confirm, my lord, that they gave microscopic opinion to Lieutenant Colonel Mangena.
Okay. Oh, to Mangena, not
no.
The gentleman here?
No, my lord.
Okay, Mangena, fine.
Yes, we submit that these affidavits complies with the provisions of section 2124 and that they should be admitted into the record. We've marked them, my lord. Exhibits N will be the affidavit of Captain Chrobla.
Right.
And exhibit 000 will be the affidavit of Captain Ntini. Yes. But before we read them into the record...
before you read them, Mr. Gomezulu, any objection?
There is no.
Yeah, we know the road relating to section 212, right?
That's correct.
4 and 8.
Yes.
So you are raising an objection.
I'm raising an objection, madam.
Right.
The basis for my objection is that firstly, there is an existing ruling by this court in terms of section 186. Those witnesses, they are the witnesses of the court.
Yeah, fine.
So the state cannot dictate how to present the evidence of the witnesses of the court.
Okay.
The court will bring its witnesses and both parties will then cross-examine from what they are going to tender as evidence before this court.
My lord, I do have an objection as well.
I also object as well, thank you.
Definitely, I've got an objection, my lord, because on this document they are saying on they are prima facie proof of their content. So we're therefore putting the state to the proof of this document. Yes.
Yeah, there's an onus on them to prove them. Fine. And then the other thing is, you must tell me, you must guide me. You know, this is a lengthy trial. These witnesses, which I intend calling in terms of section 186, normally they should be called after your witness on ballistics has testified. Is that not so, Mr. Ngomane?
It is so.
Must be so. Mr.
Yes,
Ramsiki? That's it, yeah. So he wasn't say, I also be my witnesses, man, Jagasawabi's.
So you can't present evidence.
No, I mean, the ones I'm calling, the state can do whatever it wants. But the ones, if I intend calling witnesses in terms of 186 pertaining to the ballistic evidence in this case, I've got to do that after the state, if at all, sorry, the defense, if at all, have called their witness, if they want to. They're not obliged. Are we understood?
I understand.
Okay, fine. Okay, fine.
Yes, indeed, that is so, my lord, but we just want to add that in the normal course of events, the state has got the first opportunity to call any witness, and if the state at the close of his case doesn't call the witness, it will make them available to the defense, and any party is entitled to call those witnesses, and the court may also call those witnesses.
No problem.
I'm saying this in light of Mr. Mgomezulu's argument that these are witnesses for the court. They still remain state witnesses, and are mindful of what Advocate Nisi said, that they dispute their affidavits, but section 2124, it's clear. The state will hand up these documents and affidavits and read them in the record as they remain prima facie proof until the contrary is proven.
So it does not operate like that, my lord. Once we are putting the handing in of those documents in challenge, then the state cannot simply say no, despite that contestation, I'm handing them in. Documents need to be handed in through those witnesses.
No, I'm listening to two senior advocates. And they are differing on an issue. Who should I listen to?
Yes.
Or maybe read that section.
Prima facie means precisely that.
It says no.
You can't just say I dispute that and then say you put the state to the proof of. You call witnesses to dispute what is contained in the affidavit. Fine.
Yes. Yeah. But read that section. 212, subsection 4 and 8, I think, whatever.
Yes. Section 212 is as follows. Proof, the heading is proof of certain facts by affidavit or certificate. 212 subsection 1. Whenever in criminal proceedings the question arises whether any particular act, transaction or occurrence did or did not take place in any particular department or sub-department of the state or of a provincial administration or in any branch or office of such department or such sub-department or in any particular court of law or in any particular bank, or the question arises in such proceedings whether any particular functionary in any such department, sub-department, branch of office did or did not perform any particular act or did not take part in any particular transaction, a document purporting to be an affidavit made by a person who in that affidavit alleges, paragraph A, that he is in the service of the state or a provincial administration or of the bank in question, and that is employed in the particular department or sub-department or the particular branch or office thereof or in the particular court or bank. B, that Roman figure 1, if the act, transaction or occurrence in question had taken place in such department, sub-department, branch or office or in such court or bank, or Roman figure 2, if such functionary had performed such particular act or had taken part in such particular transaction, it would be in the ordinary course of events have come to his or the deponent's knowledge, and a record thereof available to him would have been kept, and I'll proceed to subsection 4, which is relevant. Okay. And it reads as follows. 4, paragraph A, whenever any fact established by any examination or process requiring any skill in Roman figure 1 in biology, chemistry, physics, astronomy, geography or geology, Roman figure 2, in mathematics, applied mathematics or mathematical statistics, or in the analysis of statistics, Roman figure 3, in computer science or in any discipline of engineering. 4, in anatomy or in human behavioral sciences, Roman figure 5, in biochemistry, in metallurgy, in microscopy, in any branch of pathology or in toxicology, or, and this is where these exhibits come in, Roman figure 6, in ballistics, in the identification of fingerprints or body prints or in the examination of disputed documents is or may become relevant to the issue at criminal proceedings. A document purporting to be an affidavit made by a person who in that affidavit alleges that he or she is in the service of the state or of the provincial administration or any university in the republic or any body designated by the minister for the purpose of this subsection by notice in the Gazette, and that he or she has established such fact by means of such an examination or process shall, upon its mere production at such proceedings, be prima facie proof of such facts, provided that the person who may make such affidavit may, in any case in which skill is required in chemistry, anatomy, or pathology, issue a certificate in lieu of such affidavit. These are the relevant portions. So it's clear that these affidavits are on all fours, my lord, with the provisions of section 212, subsection 4.
We are all agreed. That's what the law says.
That is what the law says, my lord. However, mere production presupposes if they are not in contest. If they are not in contest, the state is put to the proof of those documents.
Now, the law says the mere production is prima facie evidence or proof, no?
Yes.
Yes.
Right. So the onus rests on who to disprove that?
Whoever wants to dispute them, my lord.
That's the point. So you can bring evidence to disprove.
No, my lord, it does not work out like that. It means there must be an agreement between us and the defense, I mean in the state.
Fine.
Yes.
You'll argue it further if you want to.
Thank you, my lord.
Because as I read the law, prima facie proof, it means the contents of the affidavit, because the deponent is normally a servant of the state, and he makes allegations regarding any aspect which relates to science, etc., geography, whatever. And that person, by mere making that affidavit, broadcast to the world that he is an expert in that field. And if the defense says otherwise, they must disprove that. But the mere production of this document puts prima facie evidence before this court. That's how I understand the law. If you think I'm wrong, no problem.
Indeed, my lord. Then we just want to briefly refer to this handbook by Himstra Criminal Procedure. Yes.
Yeah, that's the Himstra.
At page 212,
right?
He says, he calls the case of R versus Jacobson and Levy, 1931 AD 466 at 478. Says prima facie evidence in its usual sense is used to mean prima facie proof of an issue, the burden of proving which is upon the party giving that evidence. In the absence of further evidence from the other side,
conclusive,
the prima facie proof becomes conclusive proof, and the party giving it discharges his onus. And he goes on, if the accused does nothing to challenge prima facie proof, it becomes conclusive proof. And he further on says, the fact that the defense makes a statement that the contents of the certificate are not accepted, and this is what's happening here, does not affect the prima facie evidential value of that certificate. Evidential material has to be offered which rebuts the contents of the certificate. That's precisely what we say.
Okay, yeah. That's how I understand the law. Okay, are we tomorrow then?
Yes, we
sitting
can
at 10.
Yes, we can adjourn until tomorrow.
Okay, adjourn until 10 tomorrow.